A suburban home that lacks indoor plumbing suffers from, is it A, curable physical deterioration, B, functional obsolescence, C, external obsolescence, or D, incurable physical deterioration? What say you? All right, so our answer is B, functional obsolescence. Look at y'all getting the first question of the new year correct, functional obsolescence. And I think everybody put in the right answer. So I don't think we
Yeah.
need to go over the
No.
the answer unless somebody's got a question. I say we roll on to our next one.
All right. Next question. A voidable contract remains binding upon the parties until the contract is invalidated, discovered, qualified, or rescinded.
That word
Eh,
voidable. Voidable, void, valid.
Voidable.
You know you got to know those for the
Unenforceable.
test. You know you
And
do.
yep. Yep.
All right. What do we have rolling in here? We got D, we got D, we got D, we got D.
Yeah.
Mm-hmm.
They're getting too good for these questions.
I know. Rescinded.
They're rescinded until it's rescinded, until somebody
Right.
says, "Hey, this thing is void now. I'm getting out of this thing." All
Yeah.
right, Candace, this one's on you.
All right. The acts and representations of all of the following are binding on a seller of real property except. The acts and representations of all of the following are binding on a seller of real property except, is it A, the acts and representations of the buyer's broker, B, the acts and representations of the listing broker, C, the acts and representations of the subagents, or D, the acts and representations of the listing broker sales agent? So they're going to put their answer in there. And after we finish this question, I want to go back to what Mary asked, which was, can we explain void and voidable? So we'll finish this question. But so far, we got A's rolling in. Let's see. Heather says, I have absolutely no clue.
So, one thing I think we ought to say about this, that I think is kind of confusing, for at least for a lot of people, and it was for me when I was studying this at first, is about subagents. Like, so you and I started when people were still in the business that could remember when pretty much everybody was considered to represent the seller, right?
Mm-hmm.
Before we had the concept of buyer brokerage. Now, Candace and I, we're not that old, okay? But like, this is like in the 80s up until even the early 90s, I think, kind of the general consensus in real estate was everybody was either the listing agent or the listing brokerage, or they were kind of an extension of that listing brokerage trying to help find that seller a buyer. But the buyer representation idea really took off in the 1990s. Back then we had a lot of subagency. We don't really do things that way anymore. We mostly have buyer representation. But people like think, well, so if I'm a subagent, then what a subagent does, even if it's somebody from another office than the listing brokerage, could still reflect and fall back on that seller, which is why we moved towards buyer brokerage, right? And buyer representation, among other reasons. But that was a big thing. So just wanted to bring that up to you guys.
Yeah.
All right.
I mean, wait. So we have random question. If an agent is working with a seller and the seller doesn't want the agent to show the house to a certain race, is the agent better to end their relationship or ignore what the seller says and keep showing the house to anyone? I mean, I'm going to go with in the relationship because I'm not
Yeah.
trying to be down like that.
Yeah, I mean, that's the thing, like, if the person is blatant enough to come out and say, "This is what they want," and we know that's against fair housing and good common sense and normalcy,
Yeah. And
then
then,
definitely, I mean, I think that ending a relationship because of that, I agree with Candace,
yeah,
definitely. I
because
don't think
how
we
are you going to
yeah,
prove that you didn't follow their instructions? Like, I
right,
want no parts of that. Now, I do want
right,
to go
right.
back because, and that was your question before, somebody asked the difference between void and voidable.
Mhm.
So, void is something that has no legal effect whatsoever. And I like to think of two 8-year-olds. If two 8-year-olds signed on the lines, two dotted lines, they signed, would a judge hold the 8-year-old or the parents to it? No, that piece of paper has no effect whatsoever. But a voidable contract is one that looks like, hey, if it just came across the judge's desk, just looking at it, it looks good. But then if they found out, oh no, who actually signed it was somebody who was underage, who was 8. Well, then the 8-year-old could void the contract. The fact that they were 8, unless you, well, let's just leave it at that. Because they're 8, they could void it. It makes it voidable. It looks valid from the front. Like, just everything looks all hunky dory until you find out a piece of information that would allow a judge or one of the parties to say, that is the difference between void and voidable.
In a condominium apartment project, the best term to describe swimming pools and laundry rooms for the use of unit owners is it a limited common elements? Is it leasehold elements? Is it fee simple elements or common elements? What do we call these?
Ooh, we got lots of people that
Now,
knew that one quickly.
but here's the thing, it's talking about swimming pools and laundry rooms, so we know that these are common elements. But let me just ask you guys, don't look at the answer, but give me an example of a limited common element. What is an example of a limited common element? These are common elements, swimming pool, laundry room. But what would be a limited common element in a condo? Anybody think of one?
While they're
Or get
thinking one, I want to
like,
give a shout out to Nicole. I had her earlier. So, hey, Nicole. I
hey,
said I shout you
Nicole,
out. Maybe I
yeah.
didn't say it, but I am. I'm shouting out.
Yes, Nicole is one of our tutoring folks. Um, I would say, an example that I would think of would be a parking space, my
Mhm.
assigned parking space. Even though we own these common elements together as a group, the assigned parking space is part of that limited common element because it's limited to the use of that one person, right? Even though we all own it as a common element, that parking lot that's assigned to the use of one person. Another one would be a
Monica said someone's deck.
someone's deck, yes, like the patio behind your condo. Exactly. You're not supposed to be going and grilling out on my assigned deck, right? Stay on your own assigned deck.
Mhm.
Exactly. Exactly. All
So,
right.
Camille had said garden areas, and I would say maybe. Because
Yeah.
Camille, if you're in a townhome style condominium
Yeah.
where you have like what your little garden area that you would be taking care of, that would be limited common areas. But if you're in
Mhm.
something that feels more like an apartment complex and maybe there's a rose garden that everybody can walk through,
Mhm.
that would be just common areas.
Yeah.
Because the limited common area means it's limited to that one person or that one unit's use. Like a
Mhm.
personal balcony, if it's my personal balcony, I shouldn't wake up in the morning and see Maria grilling
Right.
my space.
Yes, and Jane, that's exactly, yeah, one person usually, one unit
Mhm.
is assigned to use that. Exactly.
Exactly. All right. Is it my question? Oh, wait.
Yep, it is.
One effect of a clause in a sales agreement that states that time is of the essence might be that. So, one effect of a clause in a sales agreement that states time is of the essence might be that. Is it A, the seller can take care of matters at his own convenience? Is it B, the agent must see that the contract has been fulfilled prior to closing? Is it C, all parties must attend to those details called for in the agreement in a timely manner? Or is it D, the buyer can take care of the matters at his own convenience? Y'all already know the answer. You've already thrown it in the chat. See,
Yep. All
I love
parties.
it.
All right. Jackson leases home to Sullivan with a verbal agreement to sell the property to Sullivan. Note the verbal agreement here. Jackson knows that Sullivan has been making significant improvements to the property in reliance on that verbal agreement. Jackson now declines to sell the property to Sullivan. Which of the following best describes the rights of the party? Is it A, Jackson does not have to sell because of the statute of frauds? Is it B, Jackson must sell because the doctrine of estoppel will apply in this case? Is it C, Jackson must sell because he made an ostensible agreement? Or is it D, Jackson must sell because he made an unclear agreement? What do you guys think? This one's a tricky one. I like this one.
Mhm. I will say this question has two of my least favorite words in this entire class: ostensible and estoppel.
Estoppel.
Mhm.
Estoppel.
It's such a legal,
Yeah.
they're both such legal concepts. And I'm like, why? Why?
Yeah.
But they do make sense. Once they make sense, they make sense. I'm just like, why do we have to overcomplicate it and come up with a fancy dancy word?
Basically, on Estoppel, you're relying on something that I've told you. I don't stop you from doing that. You're in good faith acting on information that I provided to you. I can't just backpedal and say, oh, no, that's not what I meant. And I'm not responsible. So that's the idea here. He led this guy to believe this is what he was trying to do. The guy acted in good faith, and now he wants to like kind of back out of it, right? And so the doctrine of Estoppel would keep him from doing that.
The applicant for a mortgage may not be asked about his or her. Is it A, number and ages of dependents? Is it B, national origin? Is it C, source of income used for repayments? Or is it D, immigration status? So don't get it wrong because you missed that not. That question says, which one can you not be asked about?
What can we not ask about? Yeah. National origin. National origin. Definitely, because that's a protected class. We're not allowed to ask about
Can
that.
anybody tell me what the other protected classes are? I mean, you've got national origin, but what are the other protected classes? All right. I love to use the acronym or the mnemonic device Fred's Corn without the vowels. So that E and that O, where do they go? Corny joke here, equal opportunity. But Fred's Corn stands for familial status, race, disability, sex, color, religion, and national origin.
If a homeowner sees another homeowner violating CC&Rs, who does the homeowner tell, or does the homeowner not say anything?
I'm going to say, Shantrisa, you've not lived in a neighborhood with HOA. Because, if you can find the homeowner who doesn't say anything, please stay. Because
Now,
a bad HOA can make your
if it
entire
doesn't
experience
have
in
an
a neighborhood.
HOA, though, he would have to tell a judge, right? They would have to take it to court to enforce it. Yep.
Well, to enforce it, they could do one or two things. They could go to a judge, ask for that injunction, or you could tell your HOA. The HOA could fine that person, and if that person doesn't pay the fine, then there could be liens put on the property, which happens especially in condos when people don't pay their dues. Because remember, in a condo, that HOA payment covers the insurance. So you don't pay, we put a lien.
Shanika asked about, and somebody else earlier, sorry, I think Tanya, and I hadn't got to this yet, about the ostensible agency question. So here's the example I give. If I ran into Kandyce at a restaurant and she was an agent, she was just one of my friends, and she says, I'm thinking about selling my house. What do you think I should get for my house? I'm like, I don't know, 500,000. I'm just making up an example here. And she says, oh, okay, cool. Well, I might have you come look at it to try to get it listed next year. Well, the next morning I show up and I knock on Kandyce's door and I bring my buyer in, and Kandyce is just kind of caught off guard. And I go in and I show my buyer Kandyce's house and I point out her kitchen and her lovely deck and her flowers and her landscaping. And I'm showing this house, and Kandyce doesn't really say anything. She just kind of, the person I'm showing the house to would believe, based on my actions, that I have the authority to act on behalf of Kandyce that way, right? That I am Kandyce's agent. That would be what a reasonable outside party looking at this would think. And that's ostensible agency. Like when a reasonable person watching this would say, oh, I think this person is the agent of this other person. That's ostensible agency. That's how I would explain it. Kandyce, how would something else?
I like to think that ostensible agency and the doctrine of estoppel kind of go hand in hand at different points in the same scenario. So you can think of ostensible agency as the same as apparent agency, which is really close to implied agency. So if in that example Maria gave, if she lets me do all of these things and move forward and all of that, and she doesn't stop me, apparently, ostensibly, I must have the authority to do all those things. I can do it because apparently it's implied. I'm saying it's implied, it's close, but ostensibly, she didn't stop me. She knew it was happening. I have that authority. It seems basically implied, for lack of a better word. Now, let's say all of that happens. Yeah, let's say all of that happens for a month, and I find a buyer. And then all of a sudden, Maria says, no, I never said you were my agent. I never said that you could do X, Y, and Z. The doctrine of estoppel says once somebody lets their actions continue on and on, they can't just be like, oh, I never really said it though. The doctrine of estoppels is that, hey, if you were doing X, Y, and Z and leading people to go down that path, you can't just go and change your mind. So hopefully that makes sense. While I think they go hand in hand.
So, which of the following could include real property? Is it leases, leasehold estates, riparian rights, or chattel? Which one could include real property? So, all leases, leasehold estates, and chattel are personal property right. Riparian rights are part of our real property. Remember, riparian rights have to do with rivers and streams flowing water. Littoral rights is lakes and oceans, things with tides, right? So that's riparian rights would be the answer here.
If a principal terminates the listing agreement during the listing period, the broker may be able to do any of the following except: is it A, recover marketing expenses, B, collect a commission for a transaction in process, C, continue to cooperate with any subsequent listing broker, or D, encourage termination of any contract in process. So 3 of these things you can do, and 1 of these things you cannot do. Which one can you not do? Which, as you can see, our answer is D, encourage termination of any contracts in process.
We got to be careful that we don't ever do this, right? As real estate agents, ethically, we cannot go around telling people to cancel contracts. I have heard agents say before, oh, well, somebody calls into my office and they were complaining about Kandyce and they said, the listing with Kandyce isn't going really well. It expires in 2 weeks, but I want to cancel the contract with Kandyce and list with you. We cannot tell the person, oh, yeah, you should definitely do that, right? And I've heard agents mistakenly do that.
I will sue you if
Cannot
I'm
do
that other agent. I will.
Yeah.
I am
Yeah.
petty. Mhm. If I can
Another thing is we have to be careful, and this is an interesting one. An example I heard in a continuing education class, which I hadn't thought of, was when we send these postcards to apartment buildings.
you have to add that language in there.
Yeah, we cannot tell people, oh, quit renting, cancel your lease and come buy a house, right? You can't just cancel your lease. You can't just encourage people to break a lease in order to buy a house with you.
Yep.
So
One of the code of
like that.
ethics says you should include the language that says, please
Mhm,
basically it says, please disregard if you are already currently in a leasing contract or a listing or buyer agency. Like this
mhm,
is only for people who are not in some type of contractual relationship.
mhm. All right, this one I'm going to do. The sheet metal that is used to protect a building from water seepage. This is kind of a different one that we haven't done before. The sheet metal that is used to protect a building from water seepage is called, is it
Hate
filter,
this stuff.
sheeting, flashing? I just had to do a whole class, 7 hours of this for C. Flashing or gutter? What is the sheet metal that is used to protect it? A lot of times we see this around our chimney, right? The
Or
flashing.
skylights. I hate it.
Mhm.
There's always something.
Yep.
There's always something on the inspection report about the flashing.
The
Always. It
flashing, yeah. The
never
flashing,
fails.
at least it's pretty easy to fix it if
Hmm.
there's
Hmm.
something wrong, but yeah, definitely. All right, Candace, how about this one?
What type of listing does an owner agree to that allows the listing broker to sell his or her property, pays the listing broker should a different broker sell it, and does not allow the seller the right to sell the property himself or herself without paying a fee? Is it ostensible agency? Is it exclusive agency? Is it open agency? Or is it exclusive right to sell? What say you? I see them rolling in the chat so fast. Look at
They
y'all.
caught it. Does not allow the seller to
Mm-mm.
the right to sell the property himself, herself without paying a fee. They caught it. What if it did? What if I had a listing with Candace that allowed her to sell this property herself without paying me as the broker a fee? What would we call that? Anybody know from the top of their head? Which one is it?
No, it wouldn't be open.
Yeah, no, it'd be exclusive agency.
Very good, Renew.
I think the thing with the open agency that's confusing is that the seller in that case, most of the time, it's the for sale by owner. They're not represented by an agent at all. So they wouldn't be paying a fee because they're not represented, period. These are listing agreements between the broker and the seller, if that helps. I don't know if that helps clear it up. Yeah.
Exactly. And
All
you said, can
right.
we give an example of exclusive agency? Exactly what she was just saying.
Yeah.
There's only one listing broker,
Mhm.
but if the seller finds the buyer, that seller does not have to pay a commission to the listing broker.
Mhm.
Okay, good.
Did I do that one or did you? I'm
I
telling
think I did.
Okay. They're both like, we got off on the topic and I was like, which one is this? My turn. All right. So the Truth in Lending Act, Regulation is Z, applies to lenders' practices. Now, Truth in Lending Act, and sometimes they interchangeably use that, calling it Regulation Z. So be on the lookout for those two, right? If the loan is $50,000 or more, is it for all business loans? Is it the loan is for commercial or agricultural loans? Or if the loan is secured by a residence? What do you guys think?
Ooh. What say you? We got
Yeah.
D's, we got D's, 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 D's.
If the loan is secured by a residence. I tell people, remember, like when I'm doing tutoring, I don't know, Candace, if you do this ever, but like my memory trick for this is like the Truth in Lending Act literally makes the bank tell the client the
Mm-hmm.
truth about what they're lending them, right? It's kind of
Mm-hmm.
describes itself. And if you think of RESPA, which is another federal law that they often ask us about, is the Real Estate Settlement Procedures Act. I know that RESPA does other things, but it's heavily focused on the settlement process, right?
Yep.
So that word settlement kind of helps me remind, like, that's the
And I
thing.
always generally
That's
say
the
that R for RESPA, it usually falls in the residential term, field. So
Yeah.
RESPA doesn't apply to commercial because residential.